Ji, Assalamu alaikum. I hope everyone is doing fine. So, welcome back to our third and last session that is going to be on investment arbitration and the modes which are related to investment arbitration. So, previous those sessions ki tarah, we have lined up a very extremely professional speaker with us, that Miss Ma'am Nusrat with us today, and she will be speaking on the topic of investment arbitration, which I believe will be an amazing experience for you all. फिर उसके बाद जो है we will be having another session that will be on investment arbitration moods कि investment arbitration के ऊपर क्या क्या moods होते हैं, पाकिस्तान में कौन से हैं और कौन से ऐसे हैं जो कि वर्ल्ड वाइड अभी एग्जिस्ट कर रहे हैं. But before going to the sessions, we also requested the presence of Ma'am Nusrat with us. We have an exciting announcement to make, जो कि सर गुलाम जो है वो अनाउंसमेंट करेंगे रिगार्डिंग एन इवेंट जो हम जो है लेकर आ रहे हैं. ओवर टू यू सर प्लीज.
Very much, Jason. Assalamu alaikum, everyone. I hope you're all doing well, and thank you for joining us for this exciting session by my personal favorite, Madam Nusrat. Just before that exciting session, we have a small yet a very big announcement for all of you. And for that, there is no one who would have been better as a guest to be present amongst us than Madam Nusrat herself. So thank you very much, Madam, for taking out the time to be present for this announcement as well. So 2 दिन पहले हमने मीडिएशंस और नेगोशिएशन कॉम्पिटिशन्स की बात की, एंड अनफॉर्चुनेटली अब तक कोई ऐसा कॉम्पिटिशन हमारी उस लिस्ट में नहीं था जो पाकिस्तान में हो. There are many trainings, many excellent trainings that are offered throughout Pakistan, but most of them are not affordable for students. So where do students go then? Students are the future ADR professionals. So we thought we would come out with a mediation program जिसके अंदर ट्रेनिंग भी हो or competition भी हो. So I will very quickly run you through this entire thing that we are doing. इसकी registrations right after this session ends, they are going to be open. ये proposal, ये सारा document आप लोगों को आपके group में भी मिल जाएगा, so please feel free to go through that. Firstly, what is Mediation and Negotiation Program in Pakistan? This is a 2-month long, 8 weeks long mediation training and competition. So during the 8 weeks, you will be trained both as mediators and negotiators. So mediators, you will get the role of the mediator, and negotiator, you will get the role of negotiator in a mediation setting. And then we will have a competition amongst those participants who are trained by amazing international and national experts. फायदा क्या होगा नेगोशिएटर रोल का? वेल, कल को जब आप जाते हैं, मीडिएशंस आर द फ्यूचर इन पाकिस्तान, एंड व्हेन यू गो टू अ मीडिएशन, लॉयर जनरली फील थ्रेटन्ड कि जी मीडिएटर जो है आ जाएगा तो हम क्या करेंगे मीडिएशन में, हमारी रोजी रोटी चली जाएगी. वेल, आपकी रोजी रोटी नहीं जाएगी, बिकॉज यू देन एक्ट एज काउंसल्स इन मीडिएशन. So when you get trained as a negotiator, you will come in and get those essential skill set which you need to participate as a counsel or as even a client in a negotiation or a mediation setting. The timeline for that, we start our registrations today. The minimum teams and everything is something I will come to in just a second. But as I said, it's going to be 8 weeks long trainings for first mediation and negotiations, followed by how to participate in a competition and then a competition. The decisions for the application will be communicated to you on 1st October, and the training program will last during November till December. And finally, in January, we will have a competition. The entire training and competition is going to be virtual. So wherever you are in the world, you can join from the convenience of your home. Why participate? It is an excellent opportunity to be trained by amazing speakers internationally and nationally. You will get a chance to not only learn, but on skills ko aap in action bhi dal sakenge in that competition. And then the costs. Costs are the most important thing, which we have kept to 4,000 per participant for the entire 2-month long competition, and then a 2-month long, training, and then the competition as well. As far as the team structure is concerned, mediator teams ke liye minimum 1 person is required to register, and for negotiator teams it's minimum 2 persons, but up to a maximum of 4 people that can register. Training में क्या फर्क पड़ेगा? Training mediator और negotiators के इकट्ठे हो. The entire training, the entire experience is going to be the same, but फर्क कहाँ पड़ेगा जब competition आएगा. So if you initially registered as a mediator, you will participate as a mediator in the competition, whereas if you registered as a negotiator, you will participate as a negotiator in the competition. How to apply? We have a very simple form that we have up on Google. We will send you the link for that again in the group. Please go through that form and register. There is no criteria that you have to be a law student or you have to be enrolled or be from a particular university. हम cross university teams भी allow कर रहे हैं, हम A levels के students भी allow कर रहे हैं. We are open to all. So please go through that. Here we have the founding team. Of course, we will have more people added to this. We have our contact numbers, our WhatsApp, our emails. So please feel free to reach out to us if you have any concerns. I look forward to seeing you all as participants and as supporters of the very first national competition and training that is centered around students, and really hope that you will have an amazing experience. Thank you very much, and over to you, Essen.
Thank you so much, and congratulations on a much needed initiative. I wish you the very best of luck and encourage the students to apply and be part of the mediation, negotiation, arbitration ecosystem in the country. So I will just share my presentation.
Ma'am, before you start, I would like to introduce you to our participants as well. Can I have a minute, please?
Yes, sure, please.
Okay, thank you. So, Assalamu alaikum, everyone. Our today's speaker is Ms. Nusrat. She's a senior partner at Samtani Qureshi Iqlal, which is a law firm which provides legal, tax, corporate advisory, and appropriate ADR solutions to your problems. Along with that, she is also a solicitor advocate and advocate to the solicitor role at England and Wales. She is the CEO of the International Center for Appropriate Dispute Resolutions and Preventions. And formerly, she has worked as a legal advisor with Infrastructure Project Development Facility, which was organized by this Ministry of Finance of Government of Pakistan. And she has also worked as a legal advisor with National Tariff Commission, Ministry of Commerce. Last but not the least, she has been awarded the Best ADR Lawyer Award in 2021 by the Ministry of Law and Justice, Pakistan. And today, Ms. Nudrat will be sharing insights on investment arbitration with our participants. Ms. Nudrat, please start your session now.
Thank you so much. Okay, so investment arbitrations in Pakistan, so far there have been about 12, 13 investment arbitrations. So it's an area that is unexplored. Not many people know about investment arbitrations. It's not something that's taught in the law schools. So I would want to give you the very basics so that you have a foundation. Once you see an investment arbitration, you should be able to know certain concepts which would be beneficial as a foundation for you. So first of all, the structure that I'm going to adopt, I'm going to take you through the main elements that form the basis of investment arbitration, concepts that differentiate investment arbitrations from commercial arbitrations, what are the fundamentals of bilateral investment treaties. So these BITs, as we call them, they are the foundation of most of the investment cases that have been filed in the world so far. Then there are certain standards that have been guaranteed under investment law, under the bilateral investment treaties. So I will take you through the standards and the role of national law in investment arbitrations. And finally, I will take you through some of the procedural dimensions so that you know what an investment arbitration looks like. So the key features of investment arbitration, things that you will see in every investment arbitration, one is going to be the parties. The parties to an investment arbitration invariably are a state at one end and an investor at the other end. The governing instruments, where do these investment arbitrations arise from? What are the instruments that govern these investment disputes? So they arise from mostly the BITs, bilateral investment treaties, sometimes from the contract. The contract has a provision says you need to go to, let's say, ICSID, SCC, which is the Stockholm Chamber of Commerce, the International Center for Settlement of Investment Disputes, the Permanent Court of Arbitration. But the governing instruments, how do you know how to regulate these disputes? So one of the key instrument is the ICSID Convention of 1965. This has been adopted by Pakistan through a legislation. It's called the Arbitration International Investment Disputes Act 2011. To enforce the awards that come from these investment arbitrations, while the ICSID Convention says that these awards are final, when it comes to time for enforcement, there is an instrument called the New York Convention of 1958 that you would have heard about. You can take the award to any country where the assets are and go to the courts of that country, have that award enforced. In Pakistan, we have legislated again the New York Convention. It's called New York Convention 1958, Recognition and Enforcement, Arbitration Agreement on Foreign Arbitral Act 2011. Then I mentioned the governing institutions, mostly it's ICSID, SCC, PCA. Then under these rules of ICSID, SCC or PCA usually uses the answer trial model law. You end up getting tribunals constituted, and we will talk a bit about that. The procedure, where does the procedure come from? How do you know how an investment arbitration is going to run? This is going to be rules of the institution. For instance, ICSID has its own arbitration rules. Now it has its own mediation rules. SCC has arbitration rules. Permanent Court of Arbitration, as I mentioned, most of the answer trial model law arbitrations end up before PCA in investment arbitrations. Then the jurisdiction, the tribunal, how far can it go? The jurisdiction of these tribunals is going to be defined by the contract from which the arbitration has arisen. It could be arising from the bilateral investment treaty. There might be a multilateral investment treaty, which says you need to go to ICSID arbitration. I focus more on ICSID because we have a law which has incorporated ICSID, legislated it into the law of Pakistan. And out of about 900 investment arbitration cases, more than 700 so far have gone to ICSID alone. Then the applicable law. What law would you apply? Usually you see it's in commercial disputes, you would see Pakistani law. It might be some other law of any other country that the parties have opted for. But in investment arbitrations, invariably the substantive law is not mentioned in the bilateral investment treaties. So the law that you have to see is going to be the international law. And the convention provides if no law is provided, then you have to see the law of the host state. The host state is the state where the investment has been made. Then comes the critical part. If you were to ask for any remedies, where would those remedies come from? So those remedies, again, are going to come from the international law. Movement of my slides is a bit slow. Now, you have some familiarity with the commercial arbitration so far. So when something comes to you, how do you really differentiate? Is it a commercial arbitration? Is it an investment arbitration? How would you really know? So some of the key differences that you will see is, for instance, the parties. In investment arbitrations, as I mentioned, it's going to be an investor against a state. In commercial arbitrations, it's usually between two private parties. Sometimes a party to a commercial arbitration can be a state as well. So that in itself, the parties don't give you a full indication. The instruments will give you an indication. In investment arbitrations, it's treaties or contracts or multilateral investment treaties. In commercial arbitrations, it's commercial contracts. The breaches in investment arbitration, it is always a breach of international obligations under the international law. In commercial arbitrations, it's contractual obligations that are breached. The governing law, investment arbitrations would be international law, invariably the national law, the convention, like ICSID convention that you're dealing with. Law of the seat. Seat basically is the place where you're having your arbitration, and the mandatory laws of that state are going to apply to your arbitration. In investment arbitrations, if it is ICSID, the law of your seat is going to be Washington, D.C. Commercial arbitrations, your governing laws would be the substantive law, the national law, that is, then the law of the seat. There might be some procedural rules here as well. For instance, commercial arbitrations might be governed by the ICC arbitration rules. So remedies, as I mentioned earlier, for investment arbitration, the remedies are coming from international law. And in particular, you would keep hearing in the international law word, the Chorzo factory case. The real pronunciation is extremely difficult, so I wouldn't even try. Most of the Pakistanis, we refer to it as Chorzo factory case. Commercial arbitrations, again, you are asking for damages and specific performance, not remedies under international law. The investment arbitrations in terms of openness are transparent, they're open to public, whereas commercial arbitrations, they are private and confidential. The purpose of investment arbitration is to protect the investment, whereas in commercial arbitrations, you're looking at enforcing commercial obligations. One of the unique things about ICSID arbitrations, in investment arbitrations in particular, is that this is an exclusive remedy. So once you have gone to ICSID, you forego any other remedies that you have. So ICSID is an exclusive remedy. So the source of the jurisdiction and the obligations, I touched upon that. They are arising, for instance, from multilateral agreements. Pakistan has over 25 multilateral agreements in force. So these are called, for instance, the free trade agreements. You've got the multilateral trade agreements. You've got the OIC investment agreement of 1981. Then the bilateral investment treaties, not a lot are remaining in force now. And 2 years back, Pakistan declared its intention to get out of the bilateral investment treaties. Still, a few are being signed. So the treaties that we did have, about 40 treaties, I think, are still going to be in force till a particular time. And then because of the sunset clauses, which says the treaty, even if you terminate it, it remains in force for a particular period. So some of the treaties would still be alive for the sunset clause, because of the sunset clause. So what are the fundamentals of these bilateral investment treaties that Pakistan has? One, it's a relationship between a foreign investor and a host state. The host state in our case would be Pakistan. So it would be, for instance, a treaty between Turkey and Pakistan. The jurisdiction and standards of protection and investment protection would be provided in the treaty. Then there would be a dispute settlement mechanism, which I think is the most important clause in the bilateral investment treaty that you would look for as soon as you have a bid case. There would be an entry into force clause and term for which that treaty is going to be alive. This again is a critical clause. Many of Pakistani cases in ICSID have been filed actually without looking at the entry into force clause. It's a lot of money to spend to find out that you got the entry into force clause wrong. The general structure, these treaties would have a preamble. It would mention who the parties are. Sometimes there are entry requirements. What investments can enter a state? What are prohibited? What legal formalities have to be fulfilled before the entry of the investment in a country? Then these treaties provide standards. What I mean by standards, I will explain in a bit. In a bit, not the bilateral investment treaty, in the British bit. I will explain in a bit. The dispute settlement mechanism, most of these treaties either say you need to go to ICSID. Sometimes they would say you need to go to the Stockholm Chamber of Commerce or the Permanent Court of Arbitration. Very rarely would you see an ICC, the International Chamber of Commerce, which is in Paris, and the London Court of International Arbitration clauses. They are quite rare, but there are some treaties, not in Pakistan, that do mention some of these centers. Entry into the force clause would let you know when that treaty is coming to an end. So again, other than the dispute settlement mechanism clause, the entry into force clause is something that you must explore thoroughly when you're dealing with the investment case. Now, what I mean by standards, in these treaties, there are certain standards or obligations that the states have undertaken. Some of the common that have been signed by Pakistan are, for instance, FET, which means fair and equitable treatment. One is full protection and security or protection and security, the national treatment standard, most favored national treatment standard, expropriation, guarantee of transfer of funds, and something that is called the umbrella clause. I will take you briefly through all of them. Now, when a state says fair and equitable treatment in a treaty, when it guarantees fair and equitable treatment, how has that been understood by the tribunals? So this standard requires that the host state, where the investment is, the state that is hosting the investment, it is required to treat the foreign investor fairly and equitably. In good faith, I have bolded some of the key terms. In good faith, without discrimination or arbitrary treatment. So this includes providing investors with the stable and predictable legal framework for their investments and protecting their legitimate expectations. So I'll unpack them, each of these terms. Now, how have the tribunals really understood and what it has actually meant? The most common one relied by the investors is legitimate expectations, which essentially means that the investor at the time of investment had an expectation and that expectation was not met. Then non-discrimination, that's apparent. You treat an investor in a way that is discriminatory. Stability and predictability, meaning you have to make sure that the investment framework in the country is stable and predictable. And you will see how that is very difficult for countries like Pakistan. Due process, this means that the FET standard requires investors will be provided with due process, including fair and impartial judicial or administrative proceedings, protection against arbitrary or discriminatory treatment, and right to be heard and to present evidence. Now, what this really looks like in real life is, for instance, the courts of Pakistan, if they were not providing access to justice, an award that could not be enforced for 13 years in India, for instance, resulted in denial of justice being violated, and it resulted in a violation of the due process. Because if you do not give someone a real chance to bring their case before court, you might end up violating your obligations under the treaty, one of them being due process. Arbitrability, the government takes a decision that is arbitrary, you will end up violating the FET. Another provision is full protection and security. What does that mean? That this standard requires the host state to provide foreign investors with full protection and security for their investments. This includes protecting investors from physical harm and ensuring their property is not expropriated or confiscated without due process and fair compensation. Provide legal protection under the regulatory framework. So physical harm, you can understand this is where, for instance, the military destroys the factory. That would be physical harm to the investment. If one was to expropriate something, that too, in some cases, has resulted in a violation of full protection and security. Now, expropriation is a standard in itself. We will talk about that. I think the more difficult part is providing legal protection under the regulatory framework. So if the laws of the country fail to provide protection to the investor, that would result in violation of the full protection and security standard. Some other standards are national treatment. What it essentially means is the state favors its own investors over investors from another country. And most favored nation treatment, this is a more complicated standard, where the standard requires the host state to treat investors from one country no less favorably than investors from any other country. This ensures that the foreign investors are not disadvantaged relative to investors from other countries. For instance, Pakistan was to commit to MFN clause. It treats an Italian investor more favorably than a Turkish investor, and you have MFN clause in the Turkish bid. The state has violated the MFN treatment. Expropriation and compensation. Again, this is one of the most agitated standards before the tribunals. This standard requires the host state to provide investors with compensation for any expropriation or nationalization of their investments. Compensation must be fair, prompt, and adequate. So direct expropriation, that people who are students of international law would know, that was easier to locate. As I said, the military goes in, takes over the factory. That's direct expropriation without compensation, without prompt and adequate compensation. What is more complex is now the concept of creeping expropriation. What that technically means is there is an expropriation of your contractual rights. So the expropriation has to be lawful. That means it has to be for a public purpose. You have to provide due process, and there needs to be a just compensation. If these three elements are missing, the state will end up violating its obligation to provide to fulfill the standard of expropriation. So I will very quickly touch on some of the other standards. Free transfer of capital. So the state is guaranteeing that the investors can take their money out of the country. Umbrella clause comes up times and times again, and it is one of the more important clauses. What happens in an umbrella clause is it's called the observance clause as well. The observance standard, it requires the host state to observe its obligations under general international law, including principles of customary international law and other international agreements to which it is a party. So some of the contractual violations made by the government of Pakistan, they have been taken to ICSID under the umbrella clause because the state has committed to observe all its commitments, including its commitments under international agreements in some of the bilateral investment treaties. So this standard elevates treaty breaches to contractual obligations. Contractual breaches to treaty breaches, and it requires the host state to honor commitments made to the investor under the treaty. So this one, the umbrella clause, is much dreaded by many of the states. Creeping expropriation, I just briefly mentioned, but Pakistan was taken to ICSID in the Karke case that many of you must have heard about. These were Turkish ships that were not allowed by the courts of Pakistan to leave the port. Provisional measures to allow ships to leave was denied. The Supreme Court of Pakistan declared the contract to be void, suspending the company's license and freezing its local bank accounts. The court declined to stay the suit on the ground that initiation of ICSID proceedings by Karke had created a situation where recourse to contractual arbitration was not possible or feasible. That is, the arbitration agreement was incapable of being performed. Another case of creeping expropriation that Pakistan saw was the Agility case. Again, these were people who the investor had brought a custom clearance software to Pakistan, and Pakistan refused to provide a rollout. After the initial few years, they said there is not going to be a national rollout of the project, and the Kuwaiti investor, Agility, they went to ICSID, claiming about $800 against Pakistan. So these are some examples of how creeping expropriation looks like. And Karke case, that is more of what the tribunals understood as a judicial expropriation, where the conduct of the courts of the country had led to an expropriation of the investment of the investor. So there are some more cases. I don't think we'll have time to go through all of them, but the cases on this slide, they related to legitimate expectations, the protection clauses and the umbrella clauses. Most of them under the legitimate expectation clauses, these investors were claiming what was committed to them by Pakistan at the time of investment was not honored by Pakistan. So in Binder case, again, you had FET, expropriation, national treatment, most favored nation treatment that was alleged to have been breached. The SGS case, which was one of the most famous ones and filed in the initial days. Umbrella clause was one of the most important breaches in that case. So in relation to now turning to jurisdiction, right? We've talked about the standards, that is the meat of the breaches, the standards that states have to observe. In terms of jurisdiction, what you have to keep in mind is most of the ICSID cases in particular would be bifurcated. The tribunals would want to see they have jurisdiction and then move on to the merits. So when you're looking at the jurisdiction, you need to make sure that what we call the rationi personae, that is, the proper people are before the tribunal. So it has to be an investor. The investor has to be of the nationality that is mentioned in the bilateral investment treaty. Then there must be an investment. The investment is defined either by the bilateral investment treaty. The ICSID convention in itself does not define investment. There is jurisprudence from the ICSID tribunals. One of the most famous cases is Salini case, which defines investment or gives the parameters, what actually is meant by investment. Consent to arbitration, the most critical aspect of jurisdiction. The state can sometimes provide their consent, as I said, from a contract. Sometimes this consent could be coming from the bilateral investment treaty, the multilateral investment treaty. And you need to look very carefully for conditions that might have been set. The dispute resolution clause might be a multi-tiered clause saying you first need to go to the courts. If you go to the courts, you cannot go to ICSID. We call this a fork in the road clause. So if you choose one, you cannot go to the other. Similarly, the provisions would say you need to try amicable settlement for 3 months. So you need to wait for 3 months, 6 months. So these conditions, these need to be satisfied, whatever the dispute settlement mechanism says. It's a clause you need to look through very carefully before going to ICSID. So what is the role of the national law then? If investment arbitrations are more about the international law, does the national law have a role to play? As I mentioned briefly, mostly the substantive law of these disputes is going to be the law of the host state. Sometimes the dispute settlement mechanism is embodied in the national law, not in Pakistan, but some states have had that case. There might be a clause in the treaty which says you need to exhaust the local remedies. That would require interaction with the local law. For interim injunctions, you have to go to the courts till the tribunal is constituted. Anti-arbitration injunctions, courts in Pakistan have in STS, Impergillo, Karki, Agility, they've attempted to prevent the ICSID proceedings without success, of course. Applicable law, as I mentioned, then the entry requirements, whether an investment can come into a particular state. The entry requirements are defined by many of the national laws. The public policy concept, again, it's something arising from the national jurisprudence. So you need to look at the jurisprudence from the courts, what is actually understood as public policy, and validity of the contract. Many of the times, the cases coming before ICSID from Pakistan, in those cases, the key question was validity of the arbitration agreement, because the allegation always has been that the contract either was procured through corruption or there was corruption somewhere down the line during the execution of the project. So when you're looking at the validity of the arbitration agreement, again, the law of the state does become relevant. So sometimes definition of investment and investor, you need the local laws to understand those. Then what is meant by state entities, instrumentalities of the state, how far can you take the definition of the state? You sometimes need to rely on the local laws. Then in Pakistan has invariably tried to justify the breaches through the national laws, that our law says this, that's why we did X, Y, and Z. But you need to remember in investment arbitrations, whenever there's a conflict between the national law and international law, the international law will always prevail. Standard of review, again, that is something where the national law becomes relevant. I won't go into details. It's a core international law concept. Now coming to the procedural dimensions, what does it actually look like when you have an ICSID arbitration? It begins with the notice to commence arbitration. There is selection of the institution, like we have taken the example of ICSID. There's appointment of arbitrators, preliminary objections are raised in relation to jurisdiction and admissibility. Some of the parties might want to ask for provisional measures or interim measures, as we call them in Pakistan. Then is the merit phase. I'll talk a bit more about that. There is the document production phase. Then there is the hearing. After the whole submissions have been submitted, there is a hearing. You would present the evidence, oral evidence during those hearings. After the hearing concludes, there will be an exchange invariably of post-hearing submissions. Now it has become a norm. Then for the award, for enforcement, you would have to take it to the courts. The court selection would depend on wherever the assets are. Let's say Pakistan, in some cases, the investors have tried to enforce the award against Pakistan, against assets in Paris, for instance. Pakistan had a hotel in Paris or PIA fleets. They have tried to enforce it against that, bank accounts that Pakistan might have in different states. So once you have an ICSID award, there is the only real remedy that you have is to go for annulment or revision in very limited cases. And annulment is very rarely awarded, very rarely considered. So the steps in arbitrations, some of you who did the law moot would have seen this. So we start with the request for arbitration. For initial screening, it goes to ICSID. ICSID will take a look and say this is prima facie outside our jurisdiction, or it is in our jurisdiction. The letter would be sent from the Secretariat to the state, that is Pakistan. The reply to the request for arbitration would be then first the request for arbitration, as I said, was step one. The reply to request for arbitration would be filed by the state. Representation of the parties, ICSID will be informed who would be representing the parties. The cost would be invariably split between the parties. The cost of ICSID, and I think the initial filing fee used to be 25,000. Maybe they've increased it now, $25,000. Then the rules of ICSID provide how you're going to constitute the tribunal. There are invariably three arbitrators who sit on ICSID arbitrations. The rules provide for requests for provisional measures, the response to claimants' requests for provisional measures, what needs to be in those requests or those replies. So then you would have a first procedural call. This is where, for the first time, all the parties and arbitrators will get together. They will decide all the key issues relating to your arbitration, the applicable arbitration rules, the presence and the quorum, the communication between the parties and the tribunal, how the tribunal is going to give those orders during the arbitration proceedings. So the place of the proceedings, multiple procedural issues, these are things that are decided early on during the first hearing, first call. So the filings, the number of copies, what is going to be the sequence of those filings, all these matters are decided at the first hearing, the first procedural hearing or the first call. So witness statements, experts, again, the rules provide guidance, and the witness statements, unlike the Pakistani courts, the witness statements are to be submitted, and the documents that you need to rely on, these are to be submitted with the pleadings. So after the pleadings have been completed, as I mentioned earlier, the pre-hearing organizational call, there you will decide all the details about the hearing venue, whether you need transcribers, translation would be required or not. The post-hearing briefs, these are things, again, that would be agreed usually on the last day of the hearing if it was not covered during the first conference call. Now, publication of the award, the convention requires that it be kept confidential, but now there is a trend where after a couple of years, the ICSID Secretariat does make the rules known to the people. And there can be public viewings as well of ICSID proceedings. So people can request that in some of the cases where national interest is being agitated by one of the parties. But generally, these are confidential proceedings. The details of the transactions are not shared in ICSID cases. Remedies, I briefly mentioned earlier. One can ask for an interpretation of the award. Annulment is the only real remedy, and it's a very limited remedy. Very rarely will tribunals annul the decision given by the tribunals in an ICSID case. So I think I will conclude with that, and I'm happy to take any questions that any of you may have. So that is investment arbitrations in a nutshell for all of you.
If you have any questions, please feel free to raise your hand and we'll unmute you, or you could also write them in the chat box. Meanwhile, ma'am, I have one question
Sure.
from you. So if as a student we're about to get started in investment arbitration, we have a particular intrigue karta and we are interested in learning more about this. What sort of books or literature would you recommend us to go through as students to be able to get a deeper understanding, first a basic and then a more deeper understanding of the subject?
So on investment arbitrations, I think one of the best books that I found was it's from Professor Schroer, so Dolzer and Schroer. That's a smaller version. Then you have, I think, the Bible on investment arbitrations is a book by Professor Schroer. It's over 1,000 pages, but that gives you essentially everything that you need to know. Then the UNCTAD website, right? All the awards and materials, the bilateral investment treaties, multilateral investment treaties. It's a good compilation of all the decisions and all the legal framework, the bilateral investment treaties and all. There is a website called JusMundi, JUSMUNDI. They have excellent resources. Many of them are freely available. Then there is a website that not many people know about. It's called Investor State Law Guide. I found that very useful as well. They have a very different, I think, collection. And Kluwer Arbitration, again, it's one of the best sites to go to for commercial arbitrations and investment arbitrations. And generally, investment arbitrations, if you want to then go into detailed study of the standards or one particular subject, there's a lot of literature now. But most of this literature is being published by Kluwer. So Kluwer has quite a good collection on investment arbitration books. But to start with, I think there's one by Redfern and Hunter. When I was at London School of Economics, that is the book that I started with, Redfern and Hunter. And the first arbitration that I attended, I was there for a jurisdictional hearing in a case, and we were in Paris. On the other side, we had an excellent team from Essex Court Chambers and the biggest firms in the world. And I was sitting there with, of course, the other materials and my Redfern and Hunter book. And one of the counsels on the other side, he says, Miss Parasha, is that a student version of Redfern and Hunter that you're consulting? And I said, yes, it is a student version, but the basics that I needed. There was only one chapter in Redfern and Hunter on investment arbitrations, but I think that pretty much boiled down all the critical concepts. So it was an excellent chapter. So someone looking to read just a chapter to know about investment arbitrations, I would say read the chapter in Redfern and Hunter. then go to Dolzer and Shores. I think the last publication was 2 years back, the latest edition. And if you're still intrigued by investment arbitrations, then I would say read the Shore's full commentary of over 1,000 pages. It is extremely enlightening.
Perfect. Thank you very much, ma'am. We have some questions in the chat box. The first one is, do ISDS protections / remedies differ from those available to domestic investors under national laws?
Yes. You see, the remedies for the local investors, I think poor local investors have no remedies. It's only what the national law is guaranteeing, which is more or less what is guaranteed to the citizens. But the regime for foreign investors, it's quite different. So there's one Foreign Investment Protection Act of, I think, 1961, which guaranteed there will be no nationalization, there will be no expropriation. The treaties specifically provide for these standards. Now, these standards are not available under the national laws. These standards are coming from the international law concepts. So the remedies that are available to the international investors, I feel they are not available to the local investors at the moment from the national legislation that we have.
Perfect. Thank you very much. The next one is, what is the current status of investment arbitration in Pakistan, and how is it addressed under the 1940 Act, including its applicability?
So in Pakistan, there is a lot of resentment and hostility amongst the government circles and the highest heads, because there have been two very recent huge awards against Pakistan, and some commercial awards again with the investor, which have been against Pakistan. So in Pakistan, we are wanting to get out of, as I said, the bilateral investment treaties. Most of the cases that went to ICSID were under the bilateral investment treaties. So Pakistan having announced that it's getting out of those treaties, that would essentially mean only through contract. Some of the investors who have a contract with the government which says you can go to ICSID, only those investors would be able to go to ICSID. But we still have, as part of our legislation, the 2011 Act, which has incorporated the ICSID Convention into the laws of Pakistan. So we still have acceptability for ICSID. The treaties that are being signed, we are, considering treaties with Saudi, we are considering with China. But in those treaties, I think we have substantially curtailed the standards. They are no longer the extensive standards and protections that we used to see in the past. So the 1940 Act, which is now in the process of being reconsidered, the arbitration laws. So the Arbitration Act 1940 did not, of course, recognize investment arbitrations or the ICSID Convention. The new law essentially says that the new law does not apply to foreign arbitrations, and it does not apply to ICSID arbitrations. So the 1940 Act is not going to be touching on these two aspects.
Thank you very much.
Does that answer the question?
For me, it does. I hope it does for Adil as well. The second last question that we have is, what happens when a country withdraws from a treaty with an ISDS agreement?
So when a country withdraws from the treaty, the BIT, as we call it, bilateral investment treaty or the multilateral investment treaty, many of these treaties, as I briefly mentioned, have what we call a sunset clause. Now, the sunset clause essentially means that while we are terminating this treaty, it is going to be available to the investors, let's say, who invested or who are covered in the next 15 years, right? So the sunset clause is essentially giving a cool-off period. So these treaties cannot be terminated in an instant. the protection would still continue to remain available. Some of the treaties say it will remain available to all the investments that were made till the date of termination, which means that though the treaty is terminated, but my investment is, let's say, 2 years prior to termination, so I'm covered. Similarly, the treaties have a cool-off period of mostly of the treaties, if I recall correctly, had a cool-off period of around 15 years. So these treaties are still going to be around for another 15 years or so.
Thank you very much. One last question before we would move on is again from myself, and that would be for students, what do you think are the next steps, very briefly, if I may? That's a very broad question, but apart from attending such webinars and the resources which you were very kind to share with us just a moment ago, what do you think are the next steps for the students to be involved in investment arbitration? What are the next steps they need to undertake?
So for students, I think the FTI moot, we've had the second moot this time in Pakistan. Moot competitions are a good idea. Then ICSID offers internships. Last year, they were considering shutting down the program, but you can check. Some of these SEC, ICSID, they do have externships and internships available. That is one place you could consider. Then the law firms having investment arbitration cases. You can consider working with them. Then some of you who would be studying abroad, maybe you get scholarships, you go for your LLM to US or UK. The professors, I think, are a very rich resource. Many of these ICSID cases or investment arbitration cases are with the professors who are sitting as arbitrators. You can consider working with them, clerking with them as or working as tribunal secretaries. And there are now courses available with, I did see one with ICC for tribunal secretaries. There are other courses relating to tribunal secretaries. That might be a good way to make a start, because that gives you an opportunity to work with these arbitrators. So the tribunal secretary courses, the centers, and the law firms having cases relating to investment arbitrations, that might be, I think, the quickest way to start.
Thank you very much for your insights there, ma'am. Once again, we are very grateful to you for taking out the time from your busy schedule to be present with us today. We are really indebted to you and very grateful for that. Something which I shared, thank you very much, ma'am. Something which I shared with our participants while you were speaking about MFN is this the most important book that I have in my library, which ma'am Nusrat very graciously gifted me on my request. So this is a book ma'am Nusrat has written. You can find it online, or you could purchase a hard copy. It's on MFN clauses. So ma'am Nusrat is one of the very few lawyers in Pakistan who actually also contributes to the bookshelves. So if you're more interested in that, please do purchase a copy and do give it a read. Once again, ma'am, we're really grateful to you for taking out the time. Thank you very much for your presence.
Thank you. Thank you. I have another meeting starting at 6, but I will take a synopsis from Faisal, what his presentation was. Okay? Sorry to be missing your presentation, Faisal.
Thank you very much, ma'am.
Thank you.
Thank you. So now you've heard from one of my favorite speakers on the subject and one of my favorite professionals in the field. And unka bhi yehi view hai ki FDI is one of the most important moods which you should get involved in if you're interested in investment arbitration. This brings me to one of my very dear friends, my brother, my colleague, Muhammad Faisal Hayat. Faisal is a final year law student at NAST Islamabad, but do not mistake him for the law student because he is at par with many professionals out there. He is currently interning at Ria Baker Gillette in Lahore. He is the founder and established the Pakistan Viz Alumni Network, where he is currently serving as an advisory board member. He has participated in numerous competitions, moot competitions, ADR. Some of them are the William C. Viz moot, the Henry Dunant moot, and so on and so forth. His team emerged as finalists in the third IAC Central Asia WISP Moot in Astana, Kazakhstan, and he coached a Wismoot team in the 31st Wismoot, which advanced to the rounds of 64 and won the East Africa WISP Moot, excuse me. He has interned at various prestigious law firms in Pakistan and abroad, and he occasionally writes for law journals on topics of human rights and private international law. Very recently, he contributed to the Kluwer Arbitration blog with an article on the 2024 Arbitration Act, which is the go-to article if you want to know about the Arbitration Act of 2024. So I will share the link for that in the chat box. But thank you very much, Faisal, for your presence and for taking out the time. And over to you. And I'm very excited to hear from you.
So, guys, I hope I'm audible, right?
So we cannot hear you.
And now,
Yes, it's a bit better.
so hello, I'm audible now.
Yes,
I
you
hope
are.
my voice is not echoing. And I was trying to thank Dr. Nudit Pracha, but then my mic was restricted and was not able to actually open the mic. And thank you so much, Adnan, for the introduction. And yeah, I would like to, go into those investment arbitration modes. But believe me, the most important teaching tool that a student can actually acquire or learn from is to actually watch the seminars or the video lectures or all those webinars that we are currently having. And as Ghulam Adnan mentioned, Dr. Nudit Pracha, she is few of people, I would say, ginti chunti ke log like in Pakistan that are really active in arbitration and are doing very selfless work. Like even like if you go to the others jurisdiction, you will not be able to find a community that is as supportive as like community in Pakistan. So whoever like come to arbitration have that interest of going to dispute resolution, there is no way back. So I always try to, keep my distance from dispute resolution because, it's an evolving subject. So of course, it's going to take time and you have to be involved in other sort of activities to keep pace with your peers, right? But this is so fascinating subject that you have to come back every time whenever you see an opportunity. So the same opportunities that I'm going to talk about today, and these are going to be mostly related to investment arbitration. And on the request of Lovit's team, I am including sports arbitration as well. Can you please move to the next slide? Yeah, so one of the prominent moot competition, or I would say a prestigious moot competition, which is related to the subject of international investment arbitration, as Dr. Nudit Pracha also mentioned, is the foreign direct investment arbitration moot. So I'm not going to go into the history of these moot competitions or into the very niche areas of these moot competition. Of course, you can always refer back to the rules of these moot competitions. So I will be going through the main crux of these moot competition, like how you can apply in that moot competition, how you can qualify for the international rounds, and how the team composition actually looks like. So first of all, like what is the subject matter for this moot competition? So most of the time, I would say like all the time, it is related to an investor who has invested in a host country. Let's say we have an investor from a very developed country, let's say USA, and that investor saw an opportunity in Pakistan and he would like to actually invest in Pakistan, right? So different countries like Pakistan holds this title of being pioneer in the bilateral investment treaties. So Pakistan was the first country to have a bilateral investment treaty with Germany. And after that, all these developing and developed countries, they started following these footsteps. So there will be a bilateral investment treaty between, let's say, Pakistan and UK, and an investor from UK, he want to invest in Pakistan. So, of course, during the performance of the contract or the completion of the contract, there is going to be disputes that would be arise out of the relationship between the parties, right? So, how to counter those disputes or how to resolve those disputes? It's a very a crucial, or I would say a very complex subject. So, the investor, they are most of the time reluctant to go to any other country whose judicial system is not that good, or is not that expeditious that they would be getting a speedy justice, right? So that's why in most of the BIT, they have included a dispute resolution clause. So this arbitration moot is a factual or a hypothetical dispute situation in which you will be representing both a host and a country where the investor has invested his money. So this is how you will be acting on the role of the counsels to resolve the dispute. So this is a subject matter. This is the kind of the dispute that you will be dealing. And I'm pretty sure Dr. Nudrat Pracha has thoroughly discussed what is actually investment arbitration is. The organizer for this moot competition is Center for International Legal Studies. So Christopher, he is one of the vice president of this research center, and it's in Salzburg, Austria. So apart from this moot competition, I hope my voice is not echoing because this is a small room. So apart from this moot competition, they have a lot of other resources. You can go and check it out. Like they have training resources and those writing and publication stuff as well. Again, the objective of this moot competition is actually to engage the student and to have that experience, like whether they should be continuing with this investment arbitration or not. Next slide, please. Yeah, so the main structure, just like other moot competition, like there are two main stages. The first is the written memos. Apart, as compared to other moot competitions, the arbitration moot competition, they are kind of special or different when it comes to submission of their memos. Like in WISMoot, you first have to submit your claimant memo. And after you submit claimant memo, you will get memo from the other university, right? And then you have to write the responsive arguments for that. And then FTA, it's a bit different from the WISMoot. So for the regional rounds or the national rounds, like before going to the global rounds, there are going to be the qualifying rounds for those global rounds, right? So in different jurisdictions, like in India, they called it as regional rounds, and in Pakistan, like we call it as national rounds, right? So in national rounds, you are not actually supposed to submit a whole memo, right? The word limit that is mentioned for FTA moot memo is almost 16,000 words, right? But for the national and the regional rounds, you are not required to submit the complete memo. Rather, you are supposed to submit the skeleton briefs. So it would be, I would say, maximum of 7 or 6 pages or maybe 5 pages. You just have to give a breakdown of your arguments. And after you submitted those skeleton briefs, then the oral hearing stage will come. So, of course, it's going to be in front of the panel of the arbitrators, and usually there are going to be 3 arbitrators. But let's say because of shortage of arbitrators or some miscommunication or something, then there might be going to 2 arbitrators depending upon the situation. So for the FTA, there are going to be preliminary rounds, and they are going to be directly the semifinals and the finals. But of course, the organizer, they reserve the right to actually have the quarterfinals as well if they are having a lot of university. Let's say 40 universities are participating. They are not going to restrict it to semifinals, right? It would not be fair for the participants. So they are going to be preliminary rounds and then semifinals and then the finals. And the purpose for having the regional and the national round is to actually establish that moot competition or spread the awareness of the investment arbitration in that region. And because of that, you can also attract the potential funding or the sponsorship. So I highlighted it in red. It's like potential. It's not guaranteed that you will be getting the sponsorship for the global round. So there might be going to like some opportunities or some stakeholders who are going to be interested in funding you, just like Bismode. Next slide, please. Yeah, so the team composition would be like for the oral rounds, let's say you are representing an investor, right? So at least 2 speakers should be presenting the investor at one hearing. So one person cannot do that, but of course, the organizer, they have again provide a flexibility regarding this, and even one person can go ahead with that, but at least 2% should be there for each hearing. And then the good thing for the FTA moot competition is that there is no limit when it comes to the team members. Like there is no limit that you should have 3 members, 6 members, 10 members, or even 100 members you can have. So, but this is for if the team is from a single institution. Let's say if I'm participating from NUST, right? So there can be like 50 or 100 students can participate in a single team for the FTA moot competition. But again, there is a special treatment when it comes to the participating teams. So for the FTA, even a team can comprise of different institutions. Let's say I'm from NUST, so 2 of my colleagues or maybe 1 of my colleagues, we formed a team with the student from LUMS or maybe from Fatma Jinnah or from any university, right? So in that case, the limit for the members would be 5. Like you can have 5 members from different institutions to constitute a team. So for the eligibility, like LLB, LM, or the GD students, they can like apply for that. And even again, this is a beauty for the FTA moot competition, that even the non-law students or the students who are not even related to this field but they are actually interested to dispute resolution, then in that case, they can request the FTA organizer to actually give them the permission to participate in this moot competition. Next slide, please. Yeah, so the registration would be at the FTI moot official website. I have also pasted the link for that. And then the registration fee is €750. So you will have to like pay it, but there is again a different in the payment. So in the rules of the FTA, they have mentioned like 2 kind of jurisdiction. So one have to pay, I believe, less a registration fee as compared to the others. So you always can go and check it out. So now the pre-moots, like for the Bismode, I think we have a lot of pre-moots, right? Even like few pre-moots are bigger than the global rounds of the FTA moot competition. But of course, we are actually putting efforts to make it popular as well. And I believe like even in Pakistan, we are having a lot of university now interested in participating in these moot competitions. So there are like few pre-moot competitions for the FTA as well, which act as warm-up rounds for the teams to prepare for the global rounds. So there is one official pre-moot which is actually organized by the FTA organization. This is the popular pre-moot for this FTA, and like they mostly require the students like or the participant to go and participate in this moot competition. Next slide, please. Yeah. So for the submission, as I mentioned, you have to submit the memo for each side, for the claimant and the respondent. And there are guidelines in the rules that you can follow, like the line spacing, the font size, or the font style, and in which format you have to submit the mood computation for the memos. And then the word limit is 16,000, and they have even mentioned penalties for if you exceed the uh, written limit. So I think for each 500 words, they are giving a penalty of maybe 5 marks or something like that. Yeah, and then after you submit your written memos, then will come the oral hearing stage. So for this, first there are going to be preliminary rounds, and the teams have to present their client like twice from each side. So in total, there are going to be 4 general rounds of a single team, right? 2 as a claimant and 2 as a respondent. And the time allocation is like 80 minutes per match. So this is going to be divided equally between the teams. So 40 minutes for the claimant, and then 40 minutes for the respondent. And then the rebuttal time period is also like more as compared to other mood competition. So you reserve usually 5 minutes, but of course it's the discretion of the teams whether they want to have like 4-minute or 3-minute rebuttals, but 5-minute rebuttals for time for the rebuttal is a rebuttal. Next slide. Yeah, so this is all about the FTI mood competition. So I would like to take questions now if you have related to FTI mood competition, or maybe you can write in the chat box, because other mood competition, they have kind of the similar team formation and all those tools. But of course, I will like start continuing. If you have any question, just raise your hand. I would happy to answer. So then the second investment arbitration mood, which is popular among the international teams, is the Frankfurt investment arbitration mood competition. So this is also related to investment arbitration, but again, this is a little different from the FTI. So the main focus is on the investment protection law. And their case study is also very interesting because they have included case scenarios from medieval age, right? From very ancient times. And then the organizer is this university, and there are other global partners. And there is one name that you will be hearing at every mood competition, and that is Professor Kroll. He's like everywhere, and hopefully, like, or possibly, he will be a global partner for this mood competition as well. And again, the objective for this mood competition is to actually give a practical touch of how the international investment arbitration actually works. Next slide. Yeah, so the team size is like a little constrained when it comes to the number of participants in these mood competitions. So they can be like 2 to 4 team members, and also they have set a limit on the coaches as well, that they should be like 2 coaches for that. And again, at least 2 members should be speaking at each hearing. And the registration process, again, from each law school, only 1 team can participate in this mood competition. And they have also set a limit to the teams who will be participating in the global rounds. So they have capped at 45 teams for the global rounds. Next slide. Yeah, so they also have national rounds, but they are not that popular, just like JASA mood competition or other mood competitions. But they have also shows that if, let's say, there are going to be more than 6 teams registered from a single region or a specific region, then they are going to have the national rounds. In that case, they will be selecting 3 top teams for the global rounds, as they have like set a cap for the maximum participation. So that's why if a region, let's say in Pakistan, if more than 6 teams are participating, then they have to conduct a regional or the national round, and then they will be selecting the top 3 teams for the global rounds. But let's say if there are 3 teams or maybe 4 teams participating, then there are not going to be any restriction on that. The deadline is that the team registration by March 1, 2025, and just like FTI moot competition, the teams have to submit the skeleton arguments a month before the competition. Next slide. Yeah, so the team, they have to submit the skeleton arguments, and it has to be in, again, PDF format. So in this moot competition, the teams are not required to submit the whole memo for the written submission. They just have to enlist their arguments on a single page. I believe they have set page limit on that as well, that you have to submit an argument on one page for the claimant and one page for the respondent. And the maximum, again, word limit is 25 words total for the both arguments. Next slide. Yeah, so for the oral hearings, again, this is a bit different for other moot competitions like FTA or WISMoot. Instead of 4 general rounds, they are going to have 3 general rounds. The reason is they have 45 teams. So according to that, they have actually done these team matchups. But of course, they have reserved the right if they are going to be, if a team is not going to participate in that competition, they are going to call for the teams for the volunteer hearing for 1 or 2 teams. Yeah. So the time for the hearing is 60 minutes. So that would be 30 minutes per side, like 30 minutes for claimant and 30 minutes for respondent. And that would include arbitrators' questions as well. And after these general rounds, the team would advance to the qualifying rounds. So again, they are going to, first they are going to do general rounds for 45 teams. After that, they are going to have the quarterfinals, then semifinals, and then finals. So for the finals, they have widen the time limit. So there are going to be 90 minutes, because even if they if the WISMoot or the other moot competition don't explicitly write about the time extension in the final round, this is going to happen, because in the final rounds, the arbitrators are going to ask questions. They are going to wait for you to make your arguments. And in those moot competition as well, sometime it even exceed 2 hours. Next slide. Yeah, so these 2 competitions are really popular for someone who is interested to participate in these simulations, like the international investment arbitration. And for those who are sports arbitration freaks, so they can participate in this moot competition as well. And this is also a very evolving subject. And yeah, every year, more and more teams are coming. So the subject matter is its main focus is to revolve the sports arbitration. And I think most of the time we use arbitration because it involves the internationality element, right? And in sports, it's always the international element. The team from one country and the team from the other country, of course, they are going to play if there is going to be any dispute between them, or if there is any dispute going to be between their board of governors and all that stuff. So then to resolve that dispute, or to resolve the dispute related to their contracts and all that, then they are going to go for the sports arbitration. The objective is to actually advance the advocacy skills and, of course, the knowledge related to the sports arbitration. The general rounds are usually held online, virtually, and then they select top 16 teams to qualify for the in-person round. So the in-person rounds, they happen in Spain, and again, each law school can have 1 team to participate in this moot competition. Next slide. Yeah, so team composition would be the minimum of 2 students or maximum of 6 students can participate as a team. And again, 2 members should be pleading from in each hearing, from the claimant side and then from the respondent side. So the confirmation of the team and all that must be communicated and approved by January 31st, 2020. For the next moot competition, it's going to be 2024. The registration process, we have to complete it by November 10, and that's on Sports Arbitration Book website as well. Next slide. Yeah, so the fee is €415, and it includes their sport arbitration boot camp as well. It's going to be entirely virtual. And then they have like discount if you are registering your team before October 30. This is going to be €315, and after they are going to have the whole amount. And this is a non-refundable, of course. And then the structure is like there is not going to be any written submission. So I have actually made a sequence of these moot competition. Like for FTA, you have to first submit a brief and then a complete memorial. And then for the Frankfurt investment arbitration, you only have to submit the argument skeleton. And then for the sport arbitration, there is no written submission. So instead, the teams have to, again, provide just two documents. First, they have to provide a skeleton, and that is 1 page, and you have to just give your arguments in the bullet points. And then you have to give a second document that would contain the legal sources or the authorities that you will be using to defend your arguments. Next slide. Yeah, so for the orals, each team is going to have like 20 minutes, so a total of 40 minutes for each round, 24 applicant side and the 24 the respondent. And of course, if arbitrators are asking a lot of questions, they can extend it to 60 minutes as well. Again, the general rounds are going to happen online, visual, and the top 16 teams would be going to spin for the in-person rounds. And there is one interesting thing for the sport arbitration moot is that there is a lot of sponsorship opportunities in this moot competition, because this is really an evolving moot competition. This is a very new for the students. So and even like the sports organization and all that, they are always interested to sponsor teams so that they get the recognition as well, right, in the legal community. And I think that would be all. Yeah. Yeah, thank you so much. If you guys have any question, you guys can let me know, and I would love to respond. Sorry if it was boring, because I know it was just information and all that, so I wasn't able to.
It was not at all boring, Faisal. I myself had the opportunity to learn many things from your presentation. Very insightful. Thank you very much for that. Participants, if you have any questions, please feel free to raise your hand or type them in the chat box. If not, we will conclude the session. Let me see. अच्छा स्पीकर बुलाने का फायदा ये होता है कि पार्टिसिपेंट्स के कोई क्वेश्चन ही नहीं होते, so that I think is a compliment in itself, Faisal, for you. So thank you very much for your insightful presentation on that and for taking out the time to be present here to give back. मैं इनको हर सेशन में ये बताता हूँ कि जब मैंने किया था तब कोई भी नहीं था, देन जब फैसल वगैरह ने किया तब थोड़े और बेहतर लोग थे, एंड जब ये हैं तब इनके पास इतने डाइवर्स पूल है स्पीकर्स that they have all the direction and all the support that they need. And if they still do not participate in these competitions, well, then that's unfortunate. So thank you very much for being that light for them. Can advocates registered with bar participate? That's a question from Amna.
Yeah, so for the FTA and other moot competition, particularly for the FTA, I think you can participate, but for that you have to first get a written consent from the organizer. But for other moot competition, they have totally put a bar that a person who have a work experience, they cannot participate.
Amazing. I hope that answers your question. But maybe if you're qualified as a lawyer, but you're enrolled in an LLM or a PhD program, maybe then you can participate.
Yeah. But if you are a practicing lawyer, then I think, and then again they have put a limit. If you have a postgraduate experience of more than 2 years, then you will not be able to participate. You will be
that's a very
for the other participants.
Yes, indeed. Thank you very much for that. Manahil raised her hand. Yes, Manahil.
Hello. Okay, so I have a question that I'll be in a few months I'll be graduate, a law student graduate, and even though I do not have experience, but in case like we have missed out these opportunities in participating it's in such moot courts. So what would be my career pathway into the arbitration, be it the international commercial or the investment arbitration besides the moot courts? Like, what kind of courses should I take up to develop my career in these particular aspects of law?
Yeah, so I will provide a concise answer and I will give floor to Adnan, and I think he's also like very familiar with this topic and he will be able to answer this very well. So I think the first thing is to get started. You have to know what is this arbitration, what is this international arbitration arena. You have to understand. And another important thing is to recognize what are the main stakeholders in this arbitration. In that way you will be able to cross all those barriers, and you will be in the right path. So I would say you attend these kind of webinars. In that way you will have somehow know of how this arbitration really works. And then there are certain accreditation courses with the mediation centers, and I think Dr. Nudar Pracha Mediation Center is going to have that course soon. So I would suggest maybe you can sign up for that. Those are little expensive, but they are like value to money. So they will also set you in the right direction. And yeah, I think apart from that, you are like knowing the arbitration, knowing the right people, and then further advancing to the arbitration as your career. Over to you, Adnan.
Thank you very much. I think that pretty much sums it up. But to give my insight there, number one, you can still participate in these moot court competitions. So they do not have a very strict, stringent criteria for graduate students, although there is some criteria. If you have until 6 months after you graduate, you can still participate in these competitions and you will still be considered as a student. That's the general criteria. So it is not a missed opportunity just yet. So if you're interested, so please go on and participate in these moot court competitions. But secondly, trainings, as Faisal rightly pointed out, there are many trainings. ICADRIP, Ma'am Nudrat Center hosts a mediation training. There is one from ADR ODR International. Then there are other courses that you can do to be an arbitrator. For example, the CIR course. CIR Pakistan branch has a course, but then again, those are paid and cost a lot of money. You can get involved in organizations. So, for example, Faisal is sitting right in front of you as an example. He's currently interning at Ria Bakar, right? So you could reach out to such law firms and intern there and get that hands-on experience in that regard as well. Then, of course, you could read more books, expand your network, connect with the right people, attend such workshops. And one thing which you can specifically do is register for the Pakistan mediation and mediation and negotiation program that we have coming up. You'll still be a student by the time that program ends, so you would get an amazing bang for the buck and would be able to learn. I hope that answers your question. I see there are no further questions, so I think
Yeah, one comment.
Yes,
One
please.
comment on that. Yeah. So, like we, the Visual Alumni Network, we usually organize a lot of workshop and training and moot competitions, and those are fully sponsored. Like we do not even charge a single penny from any students. So I would say keep in touch, and we are like soon are going to have a mediation program for the student and even for the judges in KPK. So I would say like keep in touch. I would be happy to include you in that program. And the other thing, if you were not able to participate in the moot competition, but you can still participate as an arbitrator, as a coach. But for that, first you need to get those training. You need to have the knowledge of that arbitration, and then you can jump into that community, and then you will be the part of that community. And this is where you will be able to find your career path.
Yes, so there are multiple opportunities out there for you, and you can see which one's the best for you, which one suits the best, and offers the best value. So once again, thank you very much, Faisal, for taking out the time. I'm really sure the participants had an amazing experience and were able to learn a thing or two from you. I myself had the opportunity to do so. So thank you very much for taking out the time, participants. Thank you very much for joining. that concludes our 3-day workshop series. That Ehsan, Khansa were very kind to host for all of us. They are having some internet connection issues, so otherwise I would have handed over to them to close it. But thank you very much for joining. I hope you had an amazing time, and see you guys some other day. Take care and Allah Hafiz.
Thank you so much for having me, Ghulam, and the other Lovitz
We're
organizers.
truly
Thank you
honored.
so much.